in which we vastly expanded the federal death penalty. Again, Biden and a lot of Democrats were involved with this. And there was a tension politically, or not politically, I should say, just sort of practically speaking, where they wanted executions to happen faster and more regularly, and they wanted to shorten appeals, but they also didn't want people on death row to be, deprived of lawyers with the risk of someone's potentially innocent being executed or, with their constitutional rights sort of grossly violated. Biden was involved in he was a former public defender himself, and he was trying to navigate that very narrow path. And the political conversation was kind of going along behind the scenes. Democrats and Republicans disagreed, but they were sort of hashing out these different bills. And then the Oklahoma City bombing happened, and that really transformed the debate, because it seemed like any effort to give more constitutional rights to death row prisoners would be helping someone like Timothy McVeigh. That wasn't really true, because Timothy McVeigh sort of uniquely actually gave up his appeals and said, I don't want to fight my execution. I just want to be executed. And that's part of why he was executed only a few years later. But that political, transformation meant that Congress pushed through a bill in 1996 called the Anti-Terrorism and Effective Death Penalty Act. And it had very little to do with terrorism, and it primarily reduced the ability of people on death row to file appeals. There was this idea that they were, stringing their cases along for decades as they just raised one unimportant issue after another and forced all the judges and courts to visit them. That was a bit of a myth. I mean, there were real constitutional issues in these cases, but in the wake of that bill, which is not very famous, but I think very important, not just for the death penalty, but the whole criminal justice system, it just became a lot harder if you were in prison to get a court to listen to your new evidence that you were innocent or that, you had brain damage and shouldn't be executed for that reason, right? It really hampered the ability of prisoners to get their claims heard in court.
Just the way that Emma phrased that question, where an outlier became the story that provided cover to maintain the sort of racially biased system is analogous to, what we saw with the entire outgrowth of the of so-called capital punishment. All right. So going back to the response from that 1972 case,
sure.
Texas reshapes the way that they're going to operationalize the capital punishment. They write a statute, essentially says that there needs to be the jury needs to answer three questions. Was the killing unprovoked? Was it deliberate? And does this person represent a continuing threat to society, more or less? And you write that the authors of this bill ultimately were like a little bit unsure that they had really cracked the code, as it were. So the capital punishment comes sort of roaring back. The Supreme Court revisits the question in a case versus Texas in 1976, Jurek v. Texas. Mm-hmm. And then, so basically, what do they decide at that point?
So in 1976, Texas is one of a bunch of states that have brought back the death penalty, and every state has written a somewhat different law. And the Supreme Court has to decide, are we going to bless all of these laws or none of them or just some of them? And they decide that the harshest laws, which came out of North Carolina and Louisiana, which effectively made the death penalty mandatory for certain kinds of crimes. You kill a police officer, there's no, question. You just go straight to death row if you're found guilty. They decided that that was too harsh and that the juries should be allowed to actually look at the sort of individual life circumstances of the person they're sentencing. They should be able to look at whether they feel remorse or whether they were abused as a child, sort of all the things that we now hear about in death penalty cases. So North Carolina, Louisiana said none of that. The Supreme Court said, yes, you have to have that. And so they strike down those very harsh laws. The Texas law isn't technically mandatory, but it also really limits the ability of juries to hear that kind of information because those three questions are very simple. And even to this day, you will hear prosecutors say to members of a jury, you don't have to decide whether or not this man is going to live or die. You just have to answer these three questions. And so it allows them to kind of offload responsibility. And the scholars who have kind of looked at this future dangerousness question have found that, asking juries to predict whether somebody's going to commit crimes in the future and making the death sentence based on that question, on the one hand, it can't be done. There's really no meaningful way to predict the future. But second of all, it opens the door to a lot of fear-based arguments from prosecutors. It also allows them to kind of spin, negatives into positives. Or they can. So, for example, this person is seriously mentally ill, and where in Florida or some of these other states, the defense lawyers can bring the evidence of mental illness to say this is a reason to spare this person's life. In Texas, when it's used to answer that question, it just becomes, oh, they're seriously mentally ill, so they can't have remorse, and they are going to definitely kill someone again, right? And it gives prosecutors this tool to kind of speed these cases along towards execution. So it's a very wonky story, but I wanted to tell it because I think it's a really crucial thing to understand about why Texas became the epicenter from a legal perspective.
So we have the death penalty come roaring back to the point where a presidential candidate in 93, I guess 92, flies off the campaign to make a real show of this. I mean, this is I don't want to be glib about it, but it was like how can I top that Sister Souljah moment on some level for Bill Clinton? And but then what happens from like 94 to, let's say, 2019? And I date that before, Donald Trump, had the opportunity to sort of execute his plan to up executions. 11, I think it was, since July, federal executions. But how did the death penalty, how did the fall come?
Mm-hmm, mm-hmm. So I think the peak is a little later. You have Clinton flying home, but executions really peak around 99, 2000. And this is when George W. Bush is running for president. And the fact that he has overseen the biggest, death penalty system in the country is a major feature of that electoral campaign. It wasn't the center of it because it's not like Gore was out there opposing executions. But there were a handful of big scandalous cases that made Bush look sort of bad to the left and lended a kind of circus atmosphere to the Texas death penalty in those days. There was the case of Gary Graham, where he was a black man who was potentially innocent, and the Black Panther Party and the Ku Klux Klan were out there in the streets in Huntsville outside the execution chamber protesting. CNN was covering it. There were these big dramatic cases that I think really forced Americans to look at these questions of, are we getting it right? Is someone innocent getting, potentially going to be executed? And then there was the case of Carla Faye Tucker, a woman who had a very dramatic conversion to Christianity on death row and seemed very redeemed. And I think that led a lot of evangelicals to question capital punishment. So you have these big cases, and something kind of breaks in those years. George Bush is, of course, elected. Shortly after that, 9/11, one argument I've heard is that 9/11 kind of shifts the sort of orientation of fear for Americans away from violent criminals who commit murder and to, terrorism cases and, the 9/11 hijackers. And so there's less of a sort of obsession with carrying out lots of death sentences and executions politically. Because who the sort of enemy is has changed. And then in the midst of all that, quietly, you have defense lawyers who are getting better at just case by case convincing juries to spare the lives of people, even those who have committed really terrible crimes. I mean, there's a dramatic Houston case from 2008 in which a man who was undocumented, who had been charged with sexual assault in the past, who had been deported and come back to the United States, is here in the country without documentation and kills a police officer. And this would have been the kind of textbook case for the death penalty in Texas. And his lawyer, Dana Lynn Reeser, whose story I tell in the book, manages to convince a jury to spare this man's life by doing just a lot of research on his life and finding the sort of stories and the way of understanding him that doesn't excuse the crime or the murder of a police officer, but just gives them enough information to say this man's life is worth sparing. And in case after case that happens, and so year by year, the number of new death sentences goes into decline. Prosecutors start to realize how expensive these cases are, and they can't afford to seek death sentences at a certain point. And politically, it just becomes a little less charged. All of these things sort of combine and gel, and the number of new death sentences and executions starts to tick down year by year. And I should say that Trump, of course, oversaw 13 executions, more than any president in decades. But the number of new death sentences and even the number of executions, even with those Trump executions, has been still in decline. And once Trump is no longer carrying them out, I think we're going to see over the next 2 years very, very low numbers. So this is a story of, in terms of the diminishment of this in practice, right, is this sort of, symbiotic relationship between like the Innocence Project showing that there, it's flawed, that convictions can be flawed, and lawyers, arguing to juries why you should spare someone's life, and the juries coming from society and have gotten this message that the death penalty can be flawed, that crime, in addition to terrorism maybe supplanting the big fear for Americans, is also at a record sort of decline in crime that is taking place across the country. I don't want to get into my whole lead theory and et cetera, but it's happening across the country, regardless really of what police departments are doing in any given place. And so the experience of crime that your average American has goes down significantly over this time. So all these things begin to feed into each other, and there's sort of like a virtuous, I would consider it, circle of a feedback loop. So how do we is this a story? This is a story in many respects of something that's incremental in many respects, but where do we take this next big leap to, and I guess the moratorium that was placed under Obama for the federal executions, was that under Obama? He had a sort of unofficial moratorium, and now we're waiting to see whether Biden also has one, right? And so what is the next? Is there anything that can take us to that next level where it's like we've shut the door on it? I mean, is it statutory, a federal statute? Could that control what states do, or? It couldn't control what states do. So even if, and there is a bill in Congress now to abolish the federal death penalty, I don't know, I can't, handicap its chances of success. But even if that were to pass, that would not do away with the death penalty, because Texas, a lot of other states, Florida, Missouri, would still keep carrying them out. And those states, at least politically, seem extremely unlikely to stop executing, right, and stop carrying out death sentences. Biden could do certain complex things around federal incentives that sort of incentivize states to not carry out executions, whether that's guaranteeing them better lawyers, more funding. But it's really an incremental story. And I think that series of next steps that take us from a very diminished death penalty to no death penalty at all are going to be a lot of time and effort, and it might take a very long time. But that said, I think that there's sort of a bigger lesson in all of this, which is that a lot of the arguments about whether someone's capable of redemption or mercy, are not uniquely connected to the death penalty. These questions also, circle around cases where we consider whether to send someone to prison for the rest of their life, right, without the possibility of parole at all, right, 60 years, a virtual life sentence. We still give them to people who are, 18, 19 years old. And I think that a cultural debate will shift, even if there are still executions, that kind of cultural conversation about justice and mercy and redemption for people who commit very serious crimes might shift away from just talking about the death penalty and more to these cases of essentially just throwing someone in prison for the rest of their lives. So it'll be more of a question of carceral reform. Yeah. I mean, I think that part of the point of the book for me and the research was to say that, we think of the death penalty in isolation, but it's connected to the whole justice system. It's sort of the symbolic pinnacle of a very punitive justice system. And when you take the death penalty away, or mostly take it away, and that then becomes a debate about sort of the next harshest punishments. And the Supreme Court is completely impossible at this point. Was there any period of time over the past 30 years where there was a court that might have been amenable to saying, you know what,
we now that we've evolved as a society, we realize like the state should not have the ability to premeditatedly kill someone.